When we bought the place.
77.
77?
Yeah.
Oh, 70. Okay, that's all. Good. Optimistic.
Dare I speak?
Well, thank you, everybody, for being so understanding. This is what makes Vermont so special. So for the record, just want to note that there was a recording prior to modifying a piece of microphone equipment, and now there's going to be a second recording. So if you are to access this online, there will be two separate recordings, okay? And I am going to turn the floor over to Chris. We're going to try it again, okay?
I'm gonna ask him the same question.
Got it.
Is it okay if I call you Corey?
Yes. Is it okay if I call you Chris?
Of course, yes. Corey, it's nice to meet you. I represent Bob and Trudy Fondren and Linda Titus, who live immediately adjacent to this project. My understanding is you have issued multiple reports in this matter, yes?
Yes, there's been revisions, yes.
The first one I have is dated March 12th, 2024. Does that sound like the first report you issued?
That would be about correct, yes.
And in that report, according to your analysis, a wedding at this proposed facility will generate 326 trips over the course of the entire day, right?
Perhaps at that time, that's what our estimate was. I don't know off the top of my head if that was when the error was first in the formula. So that just came out of an Excel formula that we are using to create or estimate our the traffic impact on the site.
You agree with me, the March 12th, 2024 report says there will be 326 vehicle trips per day on Kendall Road, right?
It may have said that, but I'm not sure if that was an incorrectly transcribed number or if that was our estimate at the time. It is no longer our current estimate.
If I look at your report on page 2, the first bullet point, it says frequent larger events are estimated to generate 73 trip ends in the event's beginning hour, 52 trip ends in the event's ending hour, and 326 trips over the course of the entire day. Do you dispute that language is in your report?
No, I do not. But if I may refer you to table 2 on page 7 of that report, the final numbers on those tables report 138 entering and 138 exiting trips. And that is the number that we intended to put in that bullet list. 138 plus 138 is 276. So there was an error of adding 50 in there that I cannot explain, and I apologize for the confusion.
The 326 vehicle trips per day figure was repeated in a February 12, 2025 report, correct?
Possibly. I can open that up to verify, but it would be the same issue, just a transcription error that was not caught on the in the summary bullet list. But the table, I believe, would still say the 276 number, which was the correct number.
And that error was corrected in a March 12, 2020, I'm sorry, a March 19, 2025 report. Is that right?
Yes, Chris.
And did you provide that report to the folks that you're working for?
Yes, I would have provided it to the applicant on that date.
Okay, so you would have given it to your client sometime around March 19, 2025.
That day or a few days after.
Do you dispute that the first time my clients received that report was yesterday at 1:59 p.m.?
I am unaware of when your clients received it.
You don't disagree that we saw that for the first time yesterday at 1:59 p.m.?
I don't know.
Are there And now the claim is the number of total vehicle trips per day is 276 trips per day on Kendall Road?
That was always the intended number, so I apologize for the confusion. It's that those two numbers in table 2, there was 138 entering and 138 exiting for 276 total.
Are there currently 276 vehicle trips per day on Kendall Road?
No, there are not.
When you measured vehicle trips on Kendall Road, you documented 10 to 25 vehicle trips per day on Kendall Road, correct?
Again, no, that is kind of misreported. Not necessarily misreported, but that number was understood to not be the correct number, and it even says so on the table note. It says positioning of data collector resulted in significant data loss. The way that the data collector was positioned, it wasn't a very well positioned data collector just based on the site limitations. It was used to identify general peaks to say that one day had the highest and one days weren't the highest, and that was because it's a rather labor intensive process to manually count. Table 2 from that report indicates the manual counts that we collected, and that I believe indicated that there were 51 and 41 vehicles per day that were observed.
You agree with me that on page 1 of that report, it says range of ADT vehicles per day, 10 to 25 vehicles per day, yes?
It says that with the caveat that the data collected from that data collector is inaccurate. It was used only to determine the highest volume days to count manually.
All right. So we should disregard the 10 to 25 vehicles per day as incorrect, and we should disregard 326 vehicle trips per day as incorrect, yes?
Well, the 10 to 25 is valuable in understanding which day had the highest volume for us to manually count. So that data is not an error. It's just understood that the limitations of the data collector, it doesn't represent the traffic volumes. And that was understood at the beginning.
Who set up
The
the data collector?
276 versus 326, that was a transcription error, yes.
And who set up the data collector?
I did.
Are you able to tell me by how many trips per day the proposed event space and wedding venue will increase traffic on Kendall Road?
We used our best engineering judgment to estimate the average trips that would be generated on peak event days, in more frequent average event days, and then also the rest of the week, which would be significantly less.
So on a significant event day, when there is up to a 200-person wedding with 20 to 30 staff, how many more cars will there be on Kendall Road?
Per day, there would be 276 additional vehicles on Kendall Road on that day, on the 12 days that they're doing those events.
And you do not believe those 276 additional vehicles pose any issue with respect to congestion or safety?
No, I do not. That occurs on 12 days a year. The other 40 days a year was only 44 trips per day. And the other, I think, 313 days per year, we were estimating about 10 trips per day. So we actually did an annualized trip generation estimate. And if you consider all the days of the year and sum that all up and then divide that by the number of days of the year, we were estimating that the average trip generation of the site was going to be 22 vehicles per day. And just for context, that a single family detached house is about 10 trips per day. So we are estimating, slightly more than 2 single family unit detached housing on an annualized basis is what this project would generate. understood that on the peak weekends, it's going to be much higher, but on most of the other days, it's going to be much lower.
Yeah, I appreciate you, and I appreciate that. And I think we're in agreement that when we have a large event, it's at least 276 vehicle trips per day. Yes?
Generated by the project, yes.
Your report references a peak parking demand of 73 vehicles located on the west side of Kendall Road. Is that accurate?
I don't recall off the top of my head the parking demand that we estimated.
If I look on page 4 of your report, I believe it says there is an estimated peak parking demand of 73 vehicles to be located on the west side of Kendall Road.
I apologize. I'm looking for do you know which date you're looking at on your report?
This is your February 12th, 2025 report. Just to keep things moving, do you
yes.
dispute that there?
No, I do not dispute that. And I understand that now. Yes, that's on the west side of the road versus the east side of the road. I was getting confused because I would imagine there's going to be more than 73 vehicles or 73 cars parked on site at any one time.
Is there any other place in the neighborhood that you identified where there's parking for 73 vehicles?
I'm not exactly familiar with the site layout. Is my understanding that there was a large parking lot on the west side of Kendall Road, and then on this closer to the site, there was another additional parking lot for people with mobility issues or staff or some other type of site or use.
Yes, what I'm asking you is anywhere other than the applicant's properties, are you aware of a space with parking for 73 vehicles?
No, I don't believe so.
You would agree with me that that is not typical of the rural residential area where this is located?
I don't know. I mean, it's typical of a site that would host an event for 200 people.
Is there anything else like it in the area where this site is located?
I'm sure there could be another site that's located nearby that could probably host that. But honestly, I haven't reviewed the the topography and appropriateness of parking outside of this site.
All I'm asking you is if you have seen, in actuality, not something that could possibly happen, a space for parking 73 vehicles in the neighborhood where this project is proposed to be located.
If I could, I don't know how formal you want to do with objections and stuff, but we're putting Corey in as a traffic expert, not as an aesthetic expert. And I think the question of what else might be in the neighborhood it might go to aesthetics, but it sure doesn't go to traffic. And whether or not there's I would object to the question based on relevance.
We can move past it. Corey, you say that you're under the threshold of 75 trips where an additional analysis would be necessary, yes?
Yes.
And that is based on an assumption that there will be 2.5 guests per vehicle arriving, is that right?
Yes.
How did you come up with the 2.5 guests per vehicle number?
So we've done similar types of studies at other event sites, and it's just an estimate that we used. You may find it's higher, you may find it's lower. We thought it was appropriate in this situation because it's a rather remote site that I would imagine many people would be carpooling. Furthermore, I would imagine that there would be some sort of other incentive to try to reduce the amount of people coming to site just because it's kind of, people are coming from a far distance, I would guess.
In the application, Corey, it says the addition of approximately 20 trips per day will have little to no impact as the road is currently under capacity. Is that statement accurate, that there will only be an addition of approximately 20 trips per day?
So when we do transportation impact studies, we typically look at the average trip generation of a site, not necessarily its peak trip generation site. I mentioned earlier, the Institute of Transportation Engineers surveys sites to estimate the traffic generated at a site. So for instance, if you were surveying a site, a commercial site, you wouldn't, do a trip generation count on Christmas Eve for, say a Walmart or something like that, somewhere that's going to have a high seasonal trip generation demand. So, when we're saying the average capacity, I think that was intended to indicate that, the most common type of impact on the roadway, it has no indication of capacity constraints. But even at 73 trips for 1 hour of a day, 12 times a year, my understanding of the road and the traffic volumes out there is that won't be a congestion issue. There won't be, people lined in the streets waiting to turn left out of their driveway or something like that. There's plenty of capacity at the intersections and along the roadways to process 20 trips per day. Trips per hour or 73 trips per hour.
But to get to that statement of 20 trips, you need to spread out what will be a much more concentrated impact when there is a wedding, in which case there will be 276 vehicle trips per day. Yes?
So the 20 trips per day, I don't recall exactly the 20 trips per day that's in reference to.
It's in the application.
I'm not exactly. So there's 44 trips per day for the small events, the frequent smaller events, and 276 for the larger events. Apologies for getting a little mixed up in my head. I don't know exactly where the 20 came from, so I can't speak to how that table was assembled. Table 5E in the application, if that's what you're referring to.
I'm referring to paragraph 5F, and if I'm understanding you correctly, you do not know where the statement, the addition of approximately 20 trips per day will have little to no impact as the road is currently under capacity. No idea where that came from.
I did not prepare the language for the Act 250 permit, so I would have to get back to you on that.
Will you agree with me that certainly when there's a wedding, there will be more, the trips added will be more than 20 trips per day when there is a
Yes,
wedding?
when there's a wedding, most likely, there may be a wedding with less traffic. That's the 200-person wedding. But a full capacity of wedding event will most likely have more than 20 trips per day, yes.
Thank you, Corey. Those are all the questions I have for you.
You're welcome.
So with this same criteria, other folks with party status, do you have any questions you'd like to ask?
So just
And that's, also Bob.
Bob, you can unmute and turn on your camera.
So I guess, Corey, the question I have really is around the safety of and the impact of these events. These events are going to end at a period of time, right? If you have a music event, it wraps up. We've all been to concerts, right? you got 100 cars or 75 cars leaving all at once, exiting out of the field, going down Kendall Road, and then coming to a stop at Old City Falls Road and having to merge onto Old City Falls Road. The traffic on Old City Falls Road moves really quickly. People don't expect a lot of traffic. Have you looked at and considered what that kind of exiting activity will mean? Because it seems to me, just knowing the road, that if 75 people are going to leave at once, they're going to back up at that stop at the end of Kendall Road coming down the hill. And they're going to have to figure out how to merge onto Old City Falls Road. And that means, to me, it's got to be some kind of backup up Kendall Road while that is happening. Have you looked at that? Have you considered that in your review?
So no, not specifically. And that is basically because when we were doing these calculations, for, let's say, the wedding event that we were talking about, I think we estimated, and because the duration, the exiting peak volume is lower than the entering peak volume because everybody's coming at the same time. As an event kind of tapers on, people start leaving early. So the flush at the end is a lot less than at the beginning. So we estimated that was, I think, in the mid 50s, maybe 56 vehicles per hour at the exit, which is less than a vehicle per minute. And if you think about how long it takes to come to a stop and turn right, because most people are going to be turning right, it doesn't take that long. So I'm very confident that there will not be any congestion if we were to have modeled it, which goes to the point of why I said that we it's under the threshold of 75 trips per hour. That threshold is there for a reason, and it's because that traffic volumes generation less than that generally has no significant impact to the overall traffic network. So, to your point, no, I did not specifically study it, but I am very confident that as a capacity or congestion analysis, it wouldn't be an issue. And to regards to safety, I think that narrow kind of tree-lined roads are kind of a safety benefit when it comes to speeding. Speeding is the #1 issue when it comes to safety, and anything you can do to keep people driving slow is going to keep that happening. And people just naturally tend to drive slow on dirt, narrow roads. Individual experience may be different.
Okay, that's all. That's the only question.
I have a follow-up. Corey, let me see if I can bullet in the question exactly. As I understand the source of the 75 trips during an hour, that's not something you made up, correct? Something that the Agency of Transportation uses to determine when a level of traffic impact is so minor that it doesn't have to be studied. Would you accurately, would you state what it is correct my statement, and if it needs to be, but information, the background of 75.
Yes. So 75 trips is the threshold that the Agency of Transportation set in its transportation impact study guidelines that determines whether or not a specific project merits additional analysis vis-a-vis capacity or congestion analysis for a specific study. So typically during the Act 250 process or some other permitting process, you do an initial trip generation estimate. And if it exceeds that threshold, you would do a capacity analysis. And since this did not exceed that threshold, and also the frequency of events was so few, we recommended that a full traffic capacity or congestion analysis was not warranted or merited in this situation.
Did you have any other follow-up questions, or are you all set?
No, I'm all set. I think I've convinced my client that I'm all set.
Okay. All right. You're good?
Yeah.
Okay, fantastic. We're going to move on then to address criteria 8.
And that would be criteria 1 insofar as it involves sound.
Criteria 8 is scenic beauty, aesthetics, and historic sites, which does include sound. Yes.
Okay.
We'll do.
So, I would like to go directly to, Isaac. Oh,
They're up here.
Anyone you want to be? Just keep an eye on this picture and then that'd be nice.
Next to you or next to you?
Whatever you like.
You're in frame, we're good.
so you did a report. Would you begin briefly by describing your report briefly and what were your conclusions?
Okay, I can also do an introduction and so,
Is what?
I can also introduce myself.
Yeah.
So, my name is Isaac Gold, I'm the acoustics and music consultant here at RSG. I'm a senior consultant there, I've been about 14 years. And during that time, I've been involved in various musical projects, including some Action 50 stuff, also permitting larger energy projects. Also architectural acoustics, buildings such as this. Yeah. So, for this project, I prepared a noise analysis. Basic assumption underlying the analysis is that there's a major sound source associated with the project, that is music that's produced in case of music events or say weddings. And so the way the analysis is done is we went on site and conducted a series of measurements. There were 2 speaker locations. We put a speaker there at where it's claimed to have speakers in these events, and played just a generic noise source, which is a white noise. The idea of that is it's very characteristic. So when we measure close to the speakers and then further away, we can figure out how sound reduces from the speakers to various locations. There are 3 receiver locations along the southeastern property line. There's one towards the northern property line, probably within the project area, and there's one at the northwestern kind of intersection of Kendall Road and there's off there. So the basic thing is, because it's a speaker, it's not something like a piece of construction equipment. You can just turn down the speaker if sound levels are too high. Of course, to a certain point, but that's not really practical with certain noise sources. So the idea of the noise study was not to measure the sound source in it, out what kind of sound levels from that source could be used and still fall within certain noise criteria. And 2 sets of noise criteria here. One is part of the Stratford Vermont Unified Bylaw. The second one is the Act 250 sound level precedents. The basic conclusion is that the project could be operated to comply with either set of limits, depending upon what the sound source magnitude was, what the volume was. And there are also some ideas put in there as to what could be installed so that the level of the sound source can be modulated up or down if necessary.
Interrupt you. I'd like you to go on in a minute and talk about where your conclusions were. But you talked about the town of Stratford zoning ordinance. And that is the town, you are aware, town of Stratford actually has had 2 zoning ordinances that may affect the project.
That's my understanding. There's one on this president.
And the one that you commented on in your report was the one that was adopted in 2019, 2023, after Rachel Campbell filed her municipal application, zoning application. Is that correct?
That's my understanding.
Okay. And did you do, I'm trying to recall what you put in your report, but did you do any analysis of of how the standard that was in effect at the time, the municipal zoning standard that was in effect at the time Rachel filed her application, how that compares to the Act 250 sound standard?
My understanding of that, and it's not included actually in the report, is that it essentially would be referential of the Act 250.
Okay, okay, so basically your report, you studied compliance with the 2023 zoning ordinance and you also studied Act 250 compliance, which was equivalent to the previous zoning ordinance.
That's correct.
Okay, now could you talk about what your conclusions were as to each?
So just going on to page 8 of my mouth. So our calculations based on the sound level mechanisms indicate that the sound structure of the 23 limits can be met as long as speakers used for music are limited to certain sound levels. Table 3. These limits can be increased by moving speakers further left and lowering the sound level. Speakers and these recommendations in place, we can conclude that OCFO, which is Old City Falls Oasis, adverse impact on the aesthetics of the spectrum.
Now you were quoting, can you just without quoting, can you talk about the relative compliance as to, with each standard?
Okay, so, Act 250 has, 3 different thresholds that are part of the precedent sound levels. And one of them is 70 dBA, what's called LMX, which is an LASMX, at the property lines. Even in the configuration in which we did the test, that was a measured on property lines. There is also a 55 dBA LMAX, again, also defined as LASMX, during the day. That was, and this is at the residence, this isn't at the property line. By the way, so 70 dBA property line or area of frequency. 55 dBA at the residence, and then there's a nighttime one, 7 p.m. to 7 a.m. And that's 45 dBA. So for 70 dBA, in the way that the test was done, which sound sources emitting sound levels in excess of what we expect from events, that sound level was for 55 dBA, this would be at the residence. One thing to keep in mind is we did the measurements not at the residence, but at the property. Now, the property line is not that far away from the closest residence. You would still expect to see about a 40 dB decrease in sound level from the property line to the residence for the distance. So we did the test, we got 59 dBA, which is about 4 dB above that.
Okay, so let's apply the Act 250 standard. If the commission were to set a limit for the sound, consistent with previous Act 250 cases, if you understand them, what would be the limit that would be allowed? What would be the lowest limit that would be allowed with the property?
Specifically at the property line. So, the property line precedent is the 70 dBA, but to the sound level you can measure at the property line and still meet the 55 dBA at the residence would be about 15.
Okay, so when does at what times is Act 250 precedent concerned with what the noise level, the sound level is at the house? What at houses?
So for the 55 dBA limit, it's 7 a.m. to 7 p.m.
Okay.
The 45 is 7 p.m. to 7 a.m.
Okay, so the 55 limit at a house in this particular case would translate to a 59 decibel level at the property line with comments.
Correct. So there's a southeastern property.
Okay. Now, as we, now other people have come in beside the funders and said that, gee, they're concerned about the noise that they might hear, the sound that they might hear at their properties. One property is about 2,000 feet to the north. Could you compare the level of sound that you would, that could occur at that site 2,000 feet away versus the level of sound, 59 decibel level of sound at the Farnham property?
So the property line is, saw the highest sound level is based upon the property line. Sound relatively predictably decreases over distance. It's basically the same amount of energy disperses over a larger area. And so when you're going from a distance of Farnham property line, say 2,000 feet to the southeast, or about 2,000 feet to the north, you're probably dealing with sound levels that are certainly more than 10, probably more than 15 feet lower than what was measured at Farnham property.
Okay. And did you reach a conclusion as to whether Rachel would be able to comply with the limit? First of all, the Act 250 limit at the nighttime limit at the Farnham's house.
It could be operated that way. It would just require a decrease in both sound level or installation of some kind of barrier or other.
Okay. And that can be done?
Yes.
And how about if we look at the higher, the more restrictive standard adopted by the town? Would Rachel be able to operate in compliance with that?
So there are two standards there. One of them is for basically weekdays, rain a day, and that's 70 dBA. That's equivalent to, it's the same level, but not defined as the Act 50 property line or area typically used precedent.
Okay.
The other one is.
So no problem with that.
No problem. The other one is a little harder to get at. Is it's called, I'm just pulling up the exact language here. It's persistent discernible. There really isn't an acoustic definition of that, of what that is, that I can find in places I would normally look, such as ANSI or ISO standards. Now, through the memo, I go through a way of how I tried to get out what that was. And based upon that, assumptions I have in there, could, again, assuming the source sound levels as the speakers reduce, and or a mitigation measure. So.
Before I turn them over for cross-examination, I just would, if it's okay, like to point out the what I think is relevant precedent here for interpreting his study. And this is mostly in response to the memo that I received from Chris yesterday afternoon after he received the corrected traffic study. And but I was able to do some research. Under the Act 250 precedent is case law applies the same vested rights doctrine as municipal bylaws. We have a decision in one case, one of Rachel's cases, presently before the environmental court, indicating that the old zoning ordinance will be applied in determining Rachel's compliance with the for the wedding venue. I believe that if you look under point 25.1 the e-notes, you will see, reference to the fact that, we applied, the best Red Sox in Act 250 cases. And I believe that the vested rights takes place under the Burlington Broadcasters case, which is dated November 25, 2003, that we look for determining the date of vesting for purposes of determining Act 250 compliance, is the date on which you make a municipal application. It's not the date of the Act 250 application. I believe that you have to, Rachel has to proceed diligently from the time that she made her municipal application to making her Act 250 application. We submit that she has been in contest, and we'd be happy to put Rachel on and talk about all of her efforts. The other issue is that the Vermont Supreme Court has held in, let's see, in Ray LaCroix, 2015 Vermont 49, that the shocking and offensive criteria is no lower than 55 decibels. And the Supreme Court referred to that as a long accepted Act 250 determination for allowed levels of sound. And also in the cases that are in the environmental e-notes index, beginning we're at note 762.2.3.8, the notes that the board sets, the district commission sets levels of noise allowed allowed for the applicants. It does not set after that. It is up to the applicant to comply with those conditions. In other words, you set the limit, we have to comply with it. It's not, you don't have to speculate as to whether or not we can comply with it. In this case, you have this testimony and that we can comply with it. And it's really up to Rachel. Will have to do certain things to be in compliance with it, which she's happy to do. Thank you for that.
Thank you. I'm turn it over to Chris.
Hi, Isaac. Is it okay if I call you Isaac? Sure. I'm Chris Boyle. I represent Coventry, London, and Linden Titus. I want to start with something that you said. I wrote this down because it sounded important. You said the project could be operated in a way that met the standards you identified as relevant. Is that correct?
Say that, yes.
So it could be operated. You have obviously not seen the project operate in a way that meets the standards, correct?
Project is not yet completed. Sound association has installed it.
And in order for the hypothetical to be true, for this to be operated in a way that could meet the standards, the noise from the project will have to be at or below a certain level, yes?
That's correct.
And you identify those levels in your report, right?
In case of the Bradford 2023, was my understanding, Vermont Unified Bylaw, I did identify those projects. They're identified in this book. Those aren't the levels necessary to type 2.
Let's just focus on the Stratford Unified Bylaw by now, or for now. And certainly you thought that was relevant enough for you to consider it in your report, yes?
Because my understanding is that was a potential threshold.
What is the sound level that the project must operate at in order to comply with the Stratford noise standard?
So one thing to keep in mind here before I fully answer that question is, this is assuming we're assuming speakers here. The speakers have different directivities. So if you take, normal speaker that would be used for something like a music performance or, a wedding or something of that kind, the sound level from the speaker is going to be higher in the front than it is out the back. It's also going to be higher out front than it is to the sides. So in this table, I'm giving 4 cardinal directions, basically, or 4 directions: northeast, northwest, southeast, and southwest. The direction that is planned to be towards the farm property line is the southeast, which is directly behind the speakers. So we have the sound levels there, but that's in the quietest direction from the speaker. And it's when the back of the speaker is pointing towards that property.
Let's focus on that, because I'm with you. That's pointed right at my client's front door. So what is the sound level the project must operate at 10 feet behind the speaker in order to meet the Stratford noise standard?
To meet the, let me see the language again. Persistent, discernible threshold. This is assuming that no noise barrier is used. Depending upon location, it would have to be at 10 feet behind the speaker, either 56 or 54.
You agree that the speaker sound level limit of 54 dBA, 10 feet from the speaker is relatively low, right?
So the thing about sound levels is whether the level is high or low depends upon which comparing it to.
Will you
So
say,
for a speaker used for music performance, 54 is not that high a sound, but that's for speakers, that are supposed to be creating sound.
you say in your report on page 5, quote, the speaker sound level limit of 54 dBA, 10 feet from the speaker is relatively low, end quote. So do you agree that the speaker sound level limit of 54 dBA, 10 feet from the speaker is relatively low?
That's correct, yes.
If we look in your report at figure 2, which comes towards the back of the report, it'll give us a sense of just how low 54 dBA is, right? You with me? Figure 2, page 10? dBA is the column of numbers we see running vertically in the middle of the page there, yes?
Right.
And looking at this, 54 dBA falls somewhere between the noise generated by a microwave oven at 2.5 feet and the noise generated by a field with insects, right?
It is between those 2 sources.
So in order to comply with the noise standard, the noise from this 200-person event venue at 10 feet behind the speaker where you tested, pointed directly at my client's front door, needs to be at or below the noise created by a microwave oven 2.5 feet away, and the noise generated by a field of insects.
Again, we're referring to defining the phrase persistent discernible noise.
Yes, I am.
Okay, being clear here on that. So yeah, that's the sound level necessary.
The wedding venue has to be comparable to a microwave at 2.5 feet and or a field with insects.
At 10 dB directly behind the speaker.
How about conversational speech? What is conversational speech in terms of dBA?
And one person is talking. Assuming quiet speech you're talking about 50, assuming more normal speech you're talking 55 to 60.
If I look on figure 2 in your report, on the left-hand column there, it has conversational speech, and it looks to me like that's around 60 dBA, which is
Yes.
what you just said.
Yeah, that's a higher.
Okay, so for the proposed project to meet the Stratford noise regulation, based on your analysis, it needs to be at 54 dBA.
I'm going to object. I think the question is for it to meet the Stratford zoning ordinance now in effect, which does not apply in the section 50 case. I'd ask that you clarify your question before.
Your analysis considered whether or not the project met the Stratford sound standard. Yes?
The new one.
The one you're referring to is the 2020.
Yes.
So we're talking about praise persistent.
I'm talking about the same one that you're talking, the one that you quote in the report. In order to comply with that standard that you referenced in your report, project has to be at or below 54 dBA, 10 feet behind the speaker in the southeast direction pointed towards the Fondridge front door. Yes?
So again, give you the assumptions. So this is assuming 2023 version of the Stratford Unified Bylaw, assuming that we're trying to assess relative to persistent discernible, again, doesn't have the fixed acoustical definition. We're assuming that no other mitigation is applied to the project and speakers, then your answer is yes. And it's also assuming one specific speaker.
And those are all assumptions that you made in your report, right?
That's correct.
And that's the report that's being held out to these folks as the basis on which they should issue a permit. So with that 54 dBA level, that is lower than the 60 dBA level of conversational speech, right?
Yeah, again, that's towards the higher end, but that is a sound level of conversation.
Now, when you did your analysis, and I wrote this down as well, you said you considered, quote, a major sound source, and that was music. Did I hear that testimony correctly?
So for this analysis, the major sound source at the proposed project is assumed.
There are additional sound sources at the proposed project, are there not?
Or maybe at certain times.
Well, do you understand there may be up to 200 wedding guests at the proposed project?
I didn't know that until today, but that's what my understanding is.
Okay. Are those 200 wedding guests that will be at the proposed project additional sources of sound?
Assuming people that wedding will be generating some of this.
Does your analysis account for those sources of sound in any way?
It didn't.
You have been to a wedding, right? And I don't mean it to sound like a silly question, but I've got to ask.
I-
You've heard people clap and cheer at a wedding? Does your analysis in any way account for the sound of up to 200 people clapping and cheering at a wedding at this proposed site?
It does not include sound generated.
Does your analysis account for the sound that will be generated by people talking at a wedding at the proposed site?
It's not.
Do you understand there is an 11,000 square foot parking area proposed in connection with this project?
Again, I heard that today. That wasn't compared. Oh, there it goes.
I'll represent to you that parking area is roughly 66 feet from the Fondren's property line. My question for you is, do you expect that parking area will generate noise?
The parking area itself, no, for cars entering.
Well played. Do you expect, do you expect there will be sound generated when cars start, for example?
Cars tend to generate some sound.
And when a car door closes, for example?
That happens too, yes.
And perhaps when a car horn beeps or the car chirps when the car is locked? Might that happen in the parking area?
That might happen in cars.
does your analysis account in any way for those sources of sound that will come from the vehicles and or people in the parking area 66 feet from the Conrad's property line?
The acoustical analysis does not take into account influence of sound from vehicles and the parking.
You did not do any sort of analysis, testing and or modeling related to the parking area, correct?
There's no analysis that was done.
Do you have a sense of what level the noise in the parking area would need to be at to comply with the Stratford noise standard or what has been referred to as the Act 250 precedential standard?
So with Stratford, the persistent discernible, there isn't a way I could analyze it. Considerable.
As you sit here today, there's nothing in your report about it.
There's nothing in my report about how far sound.
Is there anything in your report about the sound from up to 200 wedding guests? Is there any analysis in your report about that? I'm sorry, just so we're clear, there's not, right?
There, I didn't evaluate, sound.
We don't need to go through it in as much detail, but the I guess we're just gonna power, is it okay if I just power through it?
Got it.
Can you hear me? The same is true with respect to your analysis of compliance with the Act 250 criteria, right? In that you did not consider the noise that will be generated by 200 wedding guests, and you did not consider the noise that will be generated from activity in the parking area. Yes?
So the analysis relating to Act 250 precedents and those in 22 in Stratford, safe sound sources.
And that is only the sound generated by music being played during amplified speaking. Yes?
That's correct.
You said, and I wrote this down, the noise from the project would need to be at or below 59 dBA in order to comply with the Act 250 standards. Did I hear that correctly? I believe you testified earlier that the noise from the project will need to be at or below 59 dBA to meet the Act 250 standard. Is that correct?
So you're referring to 59 dBA is the sound level that would have to be at the property, southeastern property line, to comply with 55 dBA Act 250 precedent at the Conrad's residence.
Got it. And again, 59 dBA would be below the 60 dBA high end for conversational speech. Yes?
It would be ever so slightly.
You talked a little bit about the potential for mitigation. You have not seen any sort of actual plan, for example, something laid out on a site plan for mitigation measures, have you?
So I haven't seen a site, different site plan than the one that's shown here. Or more recent site plan than the one that's shown here in the report. That's not.
So as you sit here today, you are not aware of a specific plan to do anything to mitigate the sound coming from the venue, aside from potentially turning the music down to below the volume of conversational speech. Yes?
So you're referring to, your characterization of it, you're referring to a very specific situation, which is the analysis with respect to. So when talking about that, talking about one specific situation, it's clarified.
I'm just asking if, as you sit here today, you are aware of any specific mitigation measure that has been considered in any way that's more than theoretical.
So I talked back and forth with the applicant as to what different mitigation measures could look like.
And aside from that, has there been anything in the way of a concrete plan to mitigate sound to the levels necessary to comply with the Stratford noise standard?
What would you consider a concrete?
A description of some sort of sound barrier with fixed dimensions and location.
So I've talked back and forth with the applicant on approximately what size of barrier would be necessary, approximately what we get out of, and probably the approximate location.
Okay, but no decisions have been made as to how that would actually happen.
Again, we're talking about design characteristics.
You understand, I think, or based on reading your report, it seems to me like you understand there's a two-part process to the Queechy test, yes?
That's correct.
First, you determine if there's an adverse impact, and then if there is an adverse impact, you determine if it's undue, right?
That's correct.
In your report, you move pretty quickly past whether or not there will be an adverse effect, yes?
Just part of the assumption in the report is that it would consider at least some people to be.
On page 7 of your report, you say, quote, given that the surrounding area is rural residential and that music from the project could be audible, close quote, there likely will be an adverse impact. Yes?
Yeah, part of, again, I should repeat that part of what goes into that is that, we're talking about music. So for example, some people want to hear certain types of music, other people don't. So for some people, hearing a certain music that they don't want to hear is that not everyone is going to.
Well, I just want to talk with you about this specific project. Is it your position that a 200-person event venue at 10 Site 1 or your S2 location will not have an adverse impact on the ponderance? That's not your position, is it?
You know, what I'm saying in the report is that they might consider it.
Okay.
Okay.
You don't disagree with me that the ponderance considered.
If they consider, if they don't, you know, if they don't want music from that venue, then if they can hear the music from that, they will consider that.
Okay. So what we're talking about is whether that adverse effect is undue. Yes?
That is the second.
And that's why you looked at the Act 250 standards you did, and why you looked at the Stratford noise standard that you did, right?
That's correct.
Because if this project does not comply with the Act 250 standards, then it becomes undue in that it offends the sensibilities of a normal person. And if it does not comply with the Stratford noise standard, it violates a clear written community standard. That was at least the framework for your analysis, yes?
Agreed on part 2. Part of the question would be for the nighttime part of Stratford, 2023 Stratford 551. It's, I wouldn't agree that persistent discernible is clear. There's no defined, there's no clear, specific, consistent physical definition for that.
Well, you were able to come up with a definition of it for your report, right? You interpreted it.
I came up with an interpretation of it. And we know that again, this is.
I'm happy to go with your interpretation for our purposes here today. And just to put everything kind of in final form here, if the noise from this venue does not comply with the Stratford noise standard, then there would be an undue adverse effect. Yes?
I already answered that.
In order to comply with the Stratford noise standard, we've got to be, by your analysis, at or below 54 dBA, 10 feet behind the speaker to the southeast. Yes?
I'm going to object to that. In order to comply with the current ordinance, which is why we studied, that's what the standard would be. But in order to comply with previous ordinance, you have to comply with the traditional Act 250. So I think we beat this issue to death here, and I just don't think Chris should be allowed to keep asking the expert meaningless questions. If he's going to ask about which standard, identify the specific standard, which ordinance are we talking about and Act 250? What are we talking about?
I'm just talking to you about the standards that you addressed in your report. We can sort out later which of those apply. Certainly, it's my client's position that the zoning ordinance that was in effect when the Act 250 application was filed is the one that controls. But in order to meet the Stratford noise standard, we've got to be at or below 54 dBA, 10 feet behind the speaker to the southeast. Yes?
So again, this is the 2023 version of the standard to apply with persistent discernible noise criteria. At one of the 10 locations, assuming no other mitigation, it would have to be 54 dBA.
And if we do not hit that mark based on all those assumptions you laid out, then there would be an undue adverse effect. Yes?
So you can keep going over this. Again, this is assuming that that's the appropriate standard. And that's assuming all of the things I went over in the previous question.
All those assumptions are valid as you make them in your report. The answer to my question is yes, isn't it?
Again, assuming the 2023 version, assuming one of the 10 locations, assuming we're talking about the persistent discernible noise criteria, and assuming no other mitigation, then it would have to be 54 dBA at some point.
Okay,
Otherwise,
so
we've got an
I'm
undue
gonna
adverse
stop,
effect.
I feel like we're being, if you would like to go back to the previous Stratford, regulation and talk about that, we can, but I think we've talked about this one.
One question, I guess, for I could, would wind factor have an impact on noise?
So, wind factor.
Right.
So as far as propagation goes, so weather will have an impact on how sound propagates over a long distance. The shorter the distance is, the less of an impact. Now, one thing that's noteworthy is when we actually did the measurements, it was very still and pretty clear afternoon and evening. And generally, those are conditions that are conducive to sound immediately in the process.
We were there at different times of the year.
So I was there for about, usually one testing. Just that happened.
Okay,
I have just a couple of questions about Act 250, what's being
Okay,
described as the
and
Act
that's fair.
250 standards.
thank you.
Isaac, I believe you mentioned nighttime level of 54 dBA, is that correct? You described between 7 p.m. I'm sorry, 45.
So the active precedent for 7 p.m. to 7 a.m. at a residence is
And if I look at table 1 on page 6 of your report, you are identifying locations. Yes.
Yes, so table 1 is a corrected monitoring results.
And if I look at column S2, all of those, the values for L1, L2, and L3 exceed the 45 dBA level, do they not?
So, say L1, L2, and L3.
Yes, or S,
About 35.
and L1,
The
L2,
sound, as the sound volume, the speaker is operating during testing, it was, the locations were up.
yes, and those three locations are located on the Fondren's property line, right? L1, L2, and L3, the locations that were above 45 dBA. Thank you, sir. Those are all the questions I have. Oh, I'm sorry. In your experience, can health be impacted by noise?
So what do you try and help you?
Either physical or mental health. Have you ever seen noise have an adverse effect on someone's health?
So, people here, I'm not a doctor, right? And so there's a wide body of research on the effects of noise on health. But, if you're asking me whether I haven't been able, because I'm not a doctor, to physically examine someone. Not an answer.
Do you dispute that other people have come to the conclusion that noise can have an impact on physical and or mental?
Other people are complaining. If the sound levels are sufficient.
Thank you.
So you're not accused quite yet. Steve, do you have any additional questions that you would like to ask?
Yes.
I think I haven't chance to process it all.
Okay.
And so I don't at this time.
Okay, that's fair. Thank you. We're still giving everybody a chance. Online, Bob, did you have any additional questions for Isaac, who is the sound consultant?
No, I did not. Thank you.
Okay, thank you very much.
May I just, first of all, since I got Chris's, submission, long submission yesterday afternoon, I didn't have time to call my office and submit the, decision by the environmental board saying that the previous, zoning ordinance was applicable to wedding venues. I expect to have my secretary submit that as soon as I can have time to make a call to have her send it to you. Let me ask you, you do Act 250 sound studies all the time, correct?
Relatively.
And how many times have you been asked to study the impact of people clapping as representing an Act 250, something that couldn't be allowed in Act 250? And how about the notion of people talking as to whether that would be something that Act 250 would prohibit? Have you been asked to do studies of that?
Personally,
And are you able to make any sort of, I understand you can't study everything. Are you able to make a normative comparison between the sound of people talking or clapping versus the sound of music being played in a venue for that purpose?
so what do you mean by normal?
Two,
What do you mean by normal?
are you able to make a statement as to how how talking would compare with the level of the impact under Act 250, the sound impact under Act 250, when people talking would compare to the playing of live music?
So, to
I'll work with you to clarify the question as much as you need, but if I clarified it enough, then yes, but
Yeah, so, you're talking about in level or other levels?
no. I probably don't know enough about what you know about to be able to clarify that. So tell me what you need.
So the level will be just the overall volume. And then there's, and that's what the quantitative thing, there's a qualitative, which is, qualitatively, music different, particularly amplified music different from people talking. With that case, then certainly music is different from talking about whatever. And generally, in noise, talking nationally, amplified music is treated as a special case. Because, for one thing, we can apply it, but the other thing is, it's quite subjective as to types of music we like, and there's usually a much higher frequency content than there is for speech. That kind of thing, which makes it more noticeable, background and sort of sense.
The type of sound, and durability, and suitably for parking, so there's diffusion. Having fun.
Let me put that this way. Oftentimes I've seen sound studies done for like sawmills, and I saw running constantly. How does that compare with people classroom or in terms of the perception by people listening? How do the two compare?
So generally most standard are set up to address the more industrialized sound sources than anything else. Usually when most of the Action 50 studies I've done are for things like sawmills, quarries, gravel pits, that kind of thing, industrialized sound sources. Really, wedding event venues, particularly ones that are more idyllic, those are relatively new, and the precedents were actually based upon things like, again, quarries, private pits, sawmills, industrial.
I think I'll stop there unless.
I just have a comment. If there's going to be, back and forth about whether the current Stratford zoning ordinance and the noise regulation, that seems like something that would be appropriate for a recess now. Just making a note of the vote here.
So Chris, my understanding is that you also have a sound expert with you, somebody with you.
Oh, I thought it was with you. No, my clients have a consulting sound engineer, yes.
I just want to open that up if there's any comments from.
No, we are
Okay.
happy with the evidence that has been introduced via the testimony and cross-examination.
Sure, I just want to be. Okay. Right, so any additional comments, Steve, on this criteria?
It's sort of mind-numbing, if not deeply into it. I'm where I live is close enough that I suspect I'm going to be able to hear a significant amount of noise. And an image I use is that the situation where it's located is like a bowl. When you get to a certain point, it becomes filling out. That's been my experience in my neighborhood and other people, for example, people directly above me, the same level. I used to be able to hear their music pretty loud. So I don't think it would be, there's a few more trees in between, but not many. So I have a feeling if I use any kind of amplifier or something, I'm going to hear it. And I based this on, as I say, it's somebody on the same, just above me on the hillside, who's at the same level as this location, this event center. So anyway, it could have to be. I'm just skeptical, I guess is what it is.
Thank you. And I'm gonna turn one more time to Bob and just make sure he's all set before we move on. Bob, do you have any additional, yes, your hand is raised.
Yeah, I'll just go back to the comment I made before, which is, this is not incidental in terms of the frequency, right? That if we get 12 weddings in the summer over 18 weekends, the risk that this noise poses a problem is pretty substantial to the neighborhood. And so I think that that's something that really needs to be considered. That's all.
Okay, we have two additional comments. Again,
Again, if you can just introduce say your name and your address as well before you start speaking.
I'm Meredith Kendall, and I'm right across the road. I'm Rachel's mother. I'm right across the road. Michael and Hartney. A comment was made in similar vein at one of the last meetings about you living in a bowl and hearing the sounds of brook and hundreds of children laughing. Look at every thing. Lauren Crusoe, she's a really excited. But I have to tell you that we don't hear them at all. We don't hear Hunter and Brook children at all. From where we are, and Rachel is even farther. So the only thing I've ever heard from you, or potentially from Bob, which when he has his goat farm, or sheep farm, whatever we don't have, probably won't hear anything. I've never heard anything from your property at all. And you need to hear that, and I think it's important to be not, not blow sound out of proportion. I mean, I'm not that far from Rachel's house, and we don't hear any of our meetings at all. None.
I would like to add to that. I think another thing is that, to be respectful to Bob and, all of my neighbors, we don't plan on hosting all 12 in the summer back to back, and we want our neighbors to be aware that we want to be sympathetic to the times that they may need, and our hopes are that upon approval, that we would work with our neighbors to take into consideration special times or needs that they may have. Also, it's not just summers, we were hoping to do some fall. And, some of these may be small, but not all weddings are going to be 200 people. And I think I just wanted to mention that some people have small weddings, and there may be only 50. And then there may be 200. So there may be some variability, and those times may not necessarily be late into the evening. A lot of people like to get married in the day and have weddings throughout the day, but they may have an afternoon for them. Also, where my mother lives too, where Mr. Wilbanks, I want to be respectful to Mr. Wilbanks. I apologize that the children left kind dogs on the deck for a few years, and our dog has passed away. We do have one other dog, and we feel very respectful to them. But on that note, there are many trees between us and Mr. Wilbanks. And in fact, there's a field which you got to see today. But in back of that field, Mr. Wilbanks lives in my grandfather's old house, the yellow house. And that field is barriered by many trees all the way to the border of Mr. Wilbanks' property. I know I'm not supposed to talk, but I hope that the music that we select, my mother was recently married a year ago after my father's passing 13 to her wonderful husband, Michael. And we try to play eclectic, peaceful music, not AC/DC, Blair Dowling, or shotgun ones. Maybe a 21 so that was just I would think that, we would hope that in the event that music was, too loud for food, when we had her, wedding and event, it was very soft and quaint and eclectic, and I think very tasteful. If there was a problem with the music and it did not bring joy to people, I would hope that our neighbors would speak up, but we also are not opposed to turning the volume down if it appears that factors might come into consideration, and I'm sure this is something I wanted to ask Isaac. I mean, for most sound engineers or people that host weddings, if the music's too loud, what usually happens, Isaac?
Maybe, if you ask me like that. Unless speakers.
And also, Isaac, to angle the music at a certain way can help reduce the sound, correct?
Yeah, I mean, English speakers. Just in a certain direction where.
And there are certain things that we could do if the noise seems to be, not able to be corrected, or people were complaining, we may be able to add mitigation factors such as a barrier wall behind if it turned into something that was more than 55 dBA. And three.
Yeah, so they're probably the simplest mitigation measure.
Is that what most people do at weddings? Isaac?
It's having barriers and that kind of thing. And see, I'm done in outdoor.
So I want to be aware of the time. There is a hard stop here at 2:30. So we have two options right now. We can start on criteria 10, knowing that probably we will not get through all of it, or we will be reconvening and we can kick that next meeting off with criterion 10. But I want to make that.
Let me see if we, I think we've submitted what we have on criteria 10. That was what I submitted. And I think we're,
Folks that, go ahead.
I don't need to go.
No, you're fine.
Well, I can start, we start. And we'll just do, we don't have to do that next, we could do one next. But the question is, do we want to start another criteria, knowing that we may well not get through it? Because I can't answer a question, we can't answer a question about whether to approve you. We have to give the other
may I
parties a chance.
suggest that we can probably handle all the other criteria except 10 with simple statements. If I run, and I can give you a demonstration if you'd like, but I think you put in a question about 1G on wetlands. I assume that was because of the state comments. We believe that we believe we're not going to get the permit unless we convince the state. We think if we do convince the state, that should be the end of the discussion. So we're prepared to meet with them and make sure we resolve that. Nobody else has raised that 1G issues. As far as the criteria 2, and also the state has raised the stormwater issue. Again, we either make them happy or we don't. We think we disagree. We think we're well under the guidelines, and all we need to do is put those numbers in front of the state and have them. And so we're prepared to do that. If you want to do a recess memo or whatever, we're prepared to, we're going to make that happen anyway. As far as criteria 2 and 3, as I understand it, the question is, would you impose a condition that we comply with what we've represented? And that's, I believe we're prepared to comply with what we've represented. So, and as I read as I studied Chris's statement, as long as we comply, he believes that we comply with it. As long as we comply with what we've represented, he believes that we comply with the criteria. I think So I think we get down, I think all we really have left is criteria 10. And our, my statement, I put in a statement showing why I think we comply with criteria 10. I think we have to comply with mandatory, requirements. If it's a precatory requirement, if it's a precatory statement, then we don't have to comply with it. It's only a mandatory statement. I'm happy to, back that up with legal research if you want. And I put in a statement showing why we comply with all the mandatory requirements. And in particular, the one that people seem to oppose is is whether or not we meet the uses that are allowed by the Stratford zoning ordinance or by the current plan in the, and those, issues, the plan allows exactly what we're doing, which is an in, which I'm happy to submit to you the zoning ordinance from Stratford. That defines the in, but basically it's if we have rooms that are entered from a central entrance, then we can serve people food and have them as in guests. And we think that is, we're complying with that. And the ordinance, excuse me, the plan also allows outdoor recreation. And if hosting venues is not an outdoor recreation, I don't know what is. So we think that there's nothing in the plan that prohibits what we're proposing to do. Other people, I forget your name, but the guy, the neighbor to the south of us, left out the line of of information from the plan. The line that he left out was the park specifically authorizing us to have outdoor recreation. And if there may be a debate, the plan allows, it limits commercial activity, except for certain commercial activities, including inns and outdoor recreation. And we think we fall under both of those, and therefore we're not prohibited.
So I like what you're saying. I like what you're sort of proposing.
Yeah.
The question is for the other parties, how they want to proceed.
I have
So
a lot to say about 10 that isn't going to be completed in what is now 20 minutes.
it sounds like what John's proposing is to sort of into legal argument with respect to those things.
I don't know that that is going to be productive with respect to 10. I think the applicant will at least want an opportunity to potentially respond to points I would make. I guess at the most productive use I see of the now 19 minutes, I do have comments with respect to criterion 8 aesthetics with respect to lighting and also traffic and parking, which I think I can move us through quickly in the next 19 minutes here, which will leave criterion 10 issues potentially related to the materials that we received yesterday afternoon for when we reconvene, in a bit.
Okay, so Mr. We did not touch on the visual aesthetic impact.
So if we come back to new 10, and I attend my phone.
Well, with the caveat of, you still have them. Yeah. But you can also see that it's not going to be the way that you and I are interacting. We're not going to be able to do if you're, you have to. Okay. You want to, okay. So,
Finish off 8.
yeah, let's finish off 8. And if I can, I'll grab you too.
Yes, thank you, go ahead.
So I
We're
will
going to go right to 2:30.
We could even, could probably wrap up in 20 minutes if we wanted to go to 2:40, but maybe.
I think I can move us through this fairly quickly. You have my written comments. With respect to lighting, I will point out that based on applicant's exhibit 19, there will be 239 individual exterior light sources added in connection with this project in an area where there are very, very, very few exterior light sources currently. You heard, I think Linda mentioned how much she enjoys the quiet darkness at night. That's something that the Conrads and Linda both enjoy, that this is a place where you can enjoy the nighttime darkness and enjoy the stars. The 239 lights that will be added include lights that are mounted to signs, lights mounted to trees, lights aimed at walls, and unshielded Edison-style light bulbs that will be strung in the air. Given that there is virtually no exterior nighttime lighting in this rural residential neighborhood now, there will certainly be an adverse impact by the addition of 239 light fixtures. And that impact will be undue in that I think it will be shocking and offensive to a person of normal sensibilities. And also in that it violates a clear written community standard in the Stratford Town Plan, which prohibits precisely the type of commercial development that's being proposed, which is an event space and wedding venue, not an inn and not an outdoor recreational facility. So you've got two different ways to get to undue adverse effects with respect to lighting. One, just the sheer offensiveness of 239 individual fixtures being added, and two, that it violates the prohibition in the Stratford Town Plan on this type of commercial development in the rural residential 1 area. With respect to the undue adverse impact on aesthetics with respect to traffic and parking, you heard earlier today that, again, I guess based on the new revised numbers, there will be 270 some trips up and down Kendall Road, the quiet dirt road, every time there is a 200-person wedding. That is a massive increase in the current traffic on Kendall Road that I think would shock anyone who knew what Kendall Road was like now and saw what it became when there is a 200-person wedding plus 20 to 30 staff members. And this comes from appellant's own exhibit 30, or I guess whatever the new report exhibit number will be assigned, but these references to the number of trips per day. Also, in the exhibit that we attached to our written comments, there is an acknowledgement that the volume of traffic will become similar to the existing volume of traffic along the Justin Morrill Memorial Highway. So you're going to turn the bucolic, quiet dirt road into the Justin Morrill Memorial Highway. In addition to the traffic, there is the impact of parking. You heard testimony earlier today that there are going to be 60 to 80 cars parked in what is now a field. There was testimony that the maximum capacity for vehicles on the west side of Canyon Road is 125 vehicles. There is nothing like that anywhere in the rural residential neighborhood where this project is located, such that that development does not fit with the character of the area, and such that it is so out of line with the character of the area that it would be shockingly offensive to a person of normal sensibility. Again, you run into a violation of a written community standard as well, since this type of development is prohibited by the Stratford Town Plan, in that an event space and wedding venue is not allowed commercial use in the RR1 district. Each one of those undue adverse effects is going to destroy what my clients love about their homes in Stratford, in that they are quiet, rural communities where you interact directly with nature, where you can enjoy being outside on your land, and you do not have the volume of impact from vehicles in the form of traffic or parking light and noise that this project will generate. I would suggest to you that the report that Isaac, the sound engineer, submitted does not come anywhere close to providing a basis on which you could determine that this project complied with the applicable standards. And for that reason alone, just failing to meet that initial burden of proof, it should be denied on the basis of criterion 8. Thank you.
Yes, thank you, I'm sorry.
Okay, so, I'd like to discuss the question of adverse and undue adverse. The Quechee Lakes test has two parts. One is there an adverse impact? My research, which has been pretty extensive on adverse versus undue adverse, is that there is almost nothing. No project has ever been devised in the state of Vermont that does not have an adverse impact. The question is, every project has been ruled to have an adverse impact. The question is the impact undue? And it's only undue if you violate one of the Quechee Lake standards. There's been nothing here. There's no violation of any local community standard. There's, and I assume we'll talk about that more when we talk about the regional, or excuse me, the plan. There's no case law address finding that traffic that is of so little as to not gum up the works, and when it's small enough so that traffic moves efficiently and safely, which is the testimony here. There's nothing that says, but oh, by the way, in addition to that, the commission can go out and find the level of traffic to be shocking and offensive. The cars that we're putting in the field will look, before the cars come and after they leave, it'll look exactly like it does now. It's a hay field. It will be mowed so that people can park cars there. And when they leave, it will still be a hay field. Let's see, was there anything? There was one other point that Chris made or tried to make. And it's just not coming to me. Maybe you can, but that's, if I haven't responded to everything he's made, let me know. But there was one other point I just didn't gauge it spectrum up with. Oh, lighting, yes, lighting, thank you. Chris points to the fact that there are many luminaires. The reason for that is because we're trying to do such a good job of controlling the lighting. Most of the luminaires will be located a little above ground, and their purpose is to light walkways, and they will come on and go off as needed for people to walk on walkways. We're not talking about, usually with lighting luminaires, we're talking about, oftentimes we're talking about 20-foot lights on 20-foot poles. In this case, there's so many because we're trying to pass light only from each luminaire, only a small distance, so that the impact will be decreased, not increased. But if there's any question about the impact of lighting, there's a lighting study and a lighting schematic that has been done. And none of the light that we're proposing comes anywhere close to bleeding off this 14-acre site. And you get around to the perimeter of the site or anywhere near the perimeter, and all of the luminescent levels are at 0. And we can give you the number of that exhibit that we've produced it and put it in for you. There's,
Just,
you're the client.
okay, yeah, sorry. I just wanted to say exactly what you just said, but mainly, one thing that may be of note here is that, lighting doesn't come into effect during summer hours until about 9 o'clock at night. But, from my understanding, I'm all about safety. I just want to be very clear. I want people to walk safely, travel safely, not fall. And then my understanding from our lighting engineer is that the pathway lights are very low emission and don't travel far, but they are of sort that you could walk on a pathway and not get hurt. And that is the whole point of the lighting.
Are they motion detector? So that if someone walks by? after
Yes, they
they're
could be
running-
motion detector, but in some circumstances that can be very disturbing to the eye. And what I've heard is that because of the trees and the light being low on certain pathways, we may be able to dim them or turn them up. They go on dimmer switches so you can light them up. But even at the highest light, it's actually incredibly low and it doesn't emit any further than the walkway past in front of the people walking. I do expect, getting to and from cars, we want to make sure people don't check. This is a reason for safety.
Thank you, Rachel. Steve, I'd like to give you an opportunity.
I don't want to urge you. I consider the traffic, potential traffic congestion, things related to amount of traffic to be, have lots to do with the impact and quality. And as I tried to make clear in my petition, the status, if the roads are in some places so narrow, if we have a large group of people, large cars coming out, they come in at different times, sometimes they come out as clusters, but those roads are really dangerous. There are a lot of blind curves, and this is more intensification-based traffic. I consider that have an incredibly negative impact on quality of life. So in the situation that I live in, like right next to the road.
Thank you. I'm going to turn to online. Bob, do you have any comments on criterion 8 that you'd like to share?
Nothing beyond what was already presented. So thanks.
Thank you, Bob. Okay, so thank you all for your participation today. We are going to have to reconvene to continue with this testimony. What that date will be, we'll talk. And we will let you know.
If it's at all relevant to you, I am returning to Vermont, as of the first Monday in May for the summer. I moved to Florida because my wife said she's never going to another Vermont winter, and I want to preserve my marriage.
So winter's over, right? I was just kidding. Yes.
There was snow on the ground, and I think that's.
Right, you should have told her. Just read. Okay, so, there will be no further comments and we are now officially recessed. Yes,
And let's end the recording.
thank you.
Thanks, and thank you all again, really, for your patience.